Hello, 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 hello. Hello.
Everybody, welcome to all of you on behalf of the School of Law at BML Munjal University, and welcome to the third Constitutional Cultures lecture. At the very beginning, I must thank all of you for your patience. And in order to start off the events for the day, I would like to call Professor Preetam Barua, the Dean of the School of Law and the Director for the Center of Constitutional Values, to introduce the lecture series and our speaker for today. Thank you, Professor Preetam.
A very warm welcome to everyone to the third Constitutional Cultures lecture, followed by a panel discussion. Let me begin by first invoking some gratitude, all of you, for your patience. We are starting late, but also to those who have set up this hall and will clean up after we have left. There are several of our student volunteers who are on their way, and they should be in here anytime soon. Maybe while Justice Oak is speaking, they might take their seats, so please do bear with them. But I wanted to thank them and our team of faculty members who have organized this event and made it possible for all of us to be here. Thank you to the India International Center and Live Law, our media partner, who are live streaming this across the country, so several people will be watching online. And there's Mr. Indrajit Singh from BML Munjal University is not here today, but he was instrumental in putting this together. The Constitutional Cultures lecture is hosted with the idea of promoting a constitutional way of life. And this is not about any specific constitution, including the Indian Constitution. And it is mostly about the value of constitutive rules, which is fast being challenged across the world today. And as you all know, that whether it's a game like hockey or cricket, or an organization like a club, or even us as individuals, we have some constitutive rules that define us. It may be your constitutional morning walk, it may be your constitutional evening diary, or it may be, for Khushwant Singh, the evening whiskey. But mostly in terms of things that define us are constitutional. What we want to focus on through this initiative is that the first feature of this idea of constitutional way of life is that constitutional rules allow us something which is very important for institutions and institutional actors, which is integrity. They are rules that we cannot give up easily. They are rules where we cannot have many exceptions to them. But the second feature, I think, is more important, which is the legal philosopher Hans Kelsen perhaps recognized it and grappled with it all through his life, which is the idea that your constitutive rules, whether it's a constitution, you call it a basic norm or a grund norm, must have some connection with morality. And that means that they allow us to evaluate our desires, intuitions, and preferences, lest they are prejudices or biases, which allow us to treat others immorally, or in themselves these principles might be unethical. No wonder that preambles of constitutions articulate combined projects through moral values like justice, liberty, equality, human dignity, fraternity. And that's because they allow us to evaluate our immediate impulses. And that is why perhaps Article 13 and Article 32 in the Indian Constitution are so significant to a constitutional way of life. They demand reflection on our own convictions and the duty to demand severe justification for the exercise of authority, especially by those who are entrusted with power. And that is why in the first Constitutional Cultures lecture, which was delivered by Professor Philip Dunn, who is currently the Dean of the Faculty of Law at Humboldt University, Berlin, we questioned the idea of constitutionality and constitutional principles in legal education. The lecture was chaired by Justice Ravindra Bhatt, and several eminent constitutional lawyers and educationists had attended, and we had a very good discussion on what are the ethical principles on the basis of which legal education should shape itself. The second Constitutional Cultures lecture was delivered by Professor Susan Marks from the London School of Economics, and the topic then was human dignity as a worldly concept. And the discussion in the second lecture was about how human dignity figures in the lives of the most marginalized, and she brought in cases from across the world, and that was discussed. And in the third Constitutional Cultures lecture today, Justice Abhay Oak will be speaking about political legitimacy and the place of courts. And this has become a very important question in the life of constitutional democracies, because often leaders across the world conflate political legitimacy with electoral legitimacy. The vote, of course, as all of us know, is a very important and empowering concept when it is denied. But in countries where it is not denied, the vote is merely a marker which stands for reasons on which we have decided to vote, and which may range from complex political discussions, moral deliberations, or to manipulation through social media, the promise of alcohol, or money. It could be any of these. And therefore, it is important to think about political legitimacy afresh beyond electoral legitimacy. So that is the theme on the basis of which we have our Constitutional Cultures lecture and panel discussion today. With this, let me introduce our speaker for the day. Our speaker today is Justice Abhay Srinivas Oak, who retired as a judge of the Supreme Court earlier this year. Though those in the legal profession do not need any introduction to Justice Oak, those who are not, and perhaps for students who are not studying law, it would be good to know that he has seen it all, right from being a practicing lawyer in the trial courts in Thane, practicing in the Bombay High Court, then he was a judge at the Bombay High Court, he was the Chief Justice of Karnataka, and then he was a judge of the Supreme Court of India. And I think that the words of Justice B.R. Gavai, who just retired as the Chief Justice of India, perhaps captures the ethos with which Justice Oak served as a judge. And I quote here, Whether it was in the domain of environmental protection, in holding government accountable to the people they serve, in safeguarding the freedom of expression, even when the voices were inconvenient or unpopular, or in upholding the dignity of labor and the rights of the most marginalized, Justice Oak's decisions have consistently reaffirmed the core values enshrined in our Constitution, unquote. After his retirement, Justice Oak has been intensely involved with legal education and with reform of the legal profession, especially to provide support for young lawyers. So a warm welcome to Justice Oak. Our chair for today's lecture is noted constitutional law scholar, public intellectual, and institution builder, Professor Faizan Mustafa. He is currently the Vice Chancellor of the Chanakya National Law University, Patna. Previously, he has been the Vice Chancellor of Nalsar University of Law and the founding Vice Chancellor of National Law University, Orissa. He was also the founding Dean of the KIIT Law School and has taught at Aligarh Muslim University. His vast corpus of work in public law has been highly influential and has also been cited by the Supreme Court of India. He is a rare combination of an academic, a public intellectual, and an institution builder. I now invite Justice Oak and Professor Mustafa to the stage and take their seats here, and we can then start with the lecture. Please, sir. Stairs are a bit steep. Please have a seat. So I must warn you all that during the lecture, a large number of students and colleagues might trickle in, so please do bear with them. There are enough empty spaces. I'm sure they will not disturb you, and they will occupy those spaces. Now, with that, I request Justice Oak to kindly deliver the third Constitutional Cultures lecture. Sir, please.
Good afternoon. It's really my pleasure to be here and to address you today. Professor Pritam, Justice Muralidhar, who is online, Professor Faizan Mustafa, Professor Gurpreet Mahajan, members of the faculty of the law school, students, and ladies and gentlemen. We have elected government in our country, elected as per the Constitution of India and the laws which are enacted under the Constitution of India. The government gets legitimacy as it is an elected government. It has mandate of voters. There is adult franchise in our country, so the elected government always has mandate of voters. As it has mandate of voters and it is supported by law, the government gets authority to rule our country. But the question which arises is, can we say that a democratically elected government can be always seen as rightful? Though it may be legitimately elected government, but it is not necessary that it remains confined to the four corners of Constitution and the laws. It is always possible that a lawfully elected government, a legitimately elected government, crosses limits. It breaches the rights given to the citizens under the Constitution, rights given to the citizens under the law of the land. When I say that a democratically elected government or government elected through adult franchise can go wrong and can go really wrong, I don't want to undermine the power of our voters. perhaps the young students who must be online, they may not have learned what happened in 1977 when after internal emergency was withdrawn, a very powerful government led by Prime Minister Indira Gandhi was defeated by the voters. Again, it happened in 2004, it happened in 2014. And in many states we see that the voters sometimes take a very decisive stand. So I'm not undermining the voters. But the real issue is that once voters elect a popular government which claims legitimacy, it becomes very difficult for citizens to take any step to correct the government where it is going wrong. There are reasons and reasons. The power which a voter has to ensure that the government corrects itself, or government does not violate law, government does not commit violation of fundamental rights of citizens, there are limitations on the power of the citizen. Of course, citizens can raise their voice, they do raise their voice, but their voice either does not reach right people, or even if it reaches, it is ignored. I'll give a few examples. During last 75 years, we have seen various governments, I'm not talking about government of a particular party, committing gross violation of human rights which are part of not only fundamental rights, but basically under Article 21. Now, Article 21, as you know, has a very wide scope. Now, right to live in pollution-free atmosphere or pollution-free surroundings is also a fundamental right which is guaranteed under Article 21. Nobody can dispute that during the last several years, there has been considerable damage to our environment. May be done by government agencies, may be done by the government. And look at the scenario. There are a handful of people who raise the issue regarding environment. And I have repeatedly said, I have seen it as a lawyer, I have seen it as a judge for 22 years, that our society does not treat those who take up the fight for environment well. They don't get support. Forget about support. Sometimes they are ridiculed. Same is the case with human rights activists. Can we say that common man stands firmly behind human rights activists? We obviously cannot say that. It's very difficult for human rights activists to survive. The reason is that maybe we lack legal literacy. Maybe we lack knowledge of the constitutional provisions, basic constitutional provisions. Perhaps we feel that after we vote, our job comes to an end. And there also there is a debate. How many people vote? See, after 75 years of existence of Constitution, we have a scenario where at some places the voting is 49%. Maybe it reaches 65% or 67%. But that shows that substantial number of voters don't vote. And now option is available of nota. You can always say that I don't like any other candidate, any candidate which is contesting the election. So when we say that there is a popular government gets elected from a franchise or election where only half of the eligible voters vote. I'm talking generally. And perhaps that is where we see that sometimes governments are not responsible. Now, what are the responsibilities of the government? See, we always talk about fundamental duties of citizens. Now, basic fundamental duty is to abide by the Constitution and to respect the ideals under the Constitution. When we say that every citizen must abide by the Constitution, it follows that he must abide by the laws which are enacted under the Constitution. Now, here is the failure we see every day. I talked about violation of human rights. Somebody who stays in the next building where I stay, his human rights are illegally taken away. I don't protest. Nobody protests. Same is the case with environment. And that's why the challenge before us is that how we can ensure that the elected government, the legitimately elected government, which naturally claims political legitimacy, how we can ensure that the government, legitimate government, abides by the Constitution. It works within the four corners of Constitution. And there lies the importance of existence of the court, that is the place of the court. When I say court, it is not necessarily, I say courts, it is not necessarily the High Court or Supreme Court. We are concerned with the courts of magistrates, the sessions courts. Because when it comes to human rights violation, it is the judicial magistrate who has a role to play. When an accused is produced before him, one who is arrested, he has to see whether constitutional mandate under Article 22 has been followed, whether he has been ill-treated after he is taken into police custody, whether the grounds of arrest have been provided to him. So this is at the threshold level of a judicial magistrate that the presence of court is very important, because it is at that stage, if the learned magistrate finds that accused who is produced before the court has been illegally detained, it is at that stage either the magistrate has to release the accused or grant him bail. Same is true about the sessions court also. Power to grant bail vests in the sessions court as it vests in the court of magistrate. Now, this is the court where common man must get justice. If a person who is arrested and who is entitled to bail is denied bail by the sessions court, he has to fight a long battle. It's not easy for a litigant to approach the High Court, and High Courts have huge pendency. I am specifically on human rights. For example, take for example High Court at Allahabad. Now, if judge taking up bail matters has a cause list of 1,000 cases, 1,000 bail applications, it is physically impossible for him to deal with these cases. So pendency, sometimes, pendency of bail applications sometimes continues for 6 months, 1 year, even more than that. And then comes the role of the constitutional courts. Now, the constitutional courts perhaps have more powers to check, to keep the government under check. See, ultimately, what is the function, put it in different words, what is the function of judiciary in the context of existence of legitimate government or political legitimacy? In one sentence, I can say that the function of the courts is to ensure that the government strictly follows the Constitution. And in fact, there is a judgment of the Supreme Court that it says that the fundamental duties of citizens are also collective duties of the government, because government consists of citizens. Or in other words, judiciary must always hold government to account. That's very important. That's very important to ensure that the legitimately elected government remains legitimate and discharges its duties in terms of the Constitution. Now take case of High Courts. Now High Courts, as I said, High Courts or Supreme Court, they have wider power. Wider power is because they have writ jurisdiction. High Court has 226 jurisdiction, Supreme Court has Article 32. Whereas 226 is much wider than Article 32 jurisdiction. Now the question is whether the High Courts and whether the Supreme Court are effectively using that jurisdiction. That's the question. If a person who is languishing in jail without prospects of trial being held in near future, say for 6 years or 7 years, if he has to struggle to get bail either from the High Court or Supreme Court, notwithstanding existence of Article 21, then can we say that the courts are discharging their duty or courts are discharging the function which is expected of them? I'll give you several examples. It's not only about the human rights, it is something more. In High Court, I have seen when we sit on writ jurisdiction, you know why common man has to approach the writ court? Though we are legitimate government, though the party in power says that we are legitimately in power, a small person, a Group D employee, for technical reasons he is denied pension, then he has to come to the High Court for a writ of mandamus. I come from Maharashtra. In Aurangabad bench of Maharashtra, you will find several petitions filed by the teachers. And what is their grievance? You know, in Maharashtra, there are a number of aided schools. The schools they are fully aided by the government. So the salary of the teachers comes from the government. So if after following due process, a teacher is appointed in a primary school or secondary school, unless his appointment is approved by education officer of Jilla Parishad, he won't get salary. And therefore, even for that approval, he has to rush to the court. Another litigation which I came across, we have armed forces, and there is a provision that somebody who is discharged from the armed forces because he becomes disabled or he acquires a disability, now he is entitled to disability pension. Now look at the scenario. When a person says that I'll join armed forces, element of sacrifice is involved. But he is denied disability pension, then he has to go to the Armed Forces Tribunal. And every order of Armed Forces Tribunal which provides that disability pension should be released to a person who was working in armed forces, every order is carried to the Supreme Court. So the scenario is that even for a smallest thing, though we have legitimate government, smallest thing citizen has to approach the court. There are many high courts which are flooded with a very peculiar litigation. A small person, say, acquires a half acre of a land. He has a sale deed in his favor. There are revenue laws across India. It's a state subject, so there are state laws which say that once there is a registered sale deed, the name of the purchaser has to be entered in the revenue record, because it is important to have a revenue record in your name. But there are many states where, though there is a mandatory provision in the local law that a person who purchases a property, his name should be entered in revenue record, he has to come to writ court to seek redressal. In our system, we have members of the parliament, we have the members of the legislative assemblies, and wherever there are legislative councils, we have members of the legislative council. Then after 1994, after constitution amendment, we have given importance to local self-government. There are municipalities, municipal corporations, there are village panchayats, there are panchayat samitis, there are Jilla Parishads. They are all local self-governments. And even those local self-governments are ruled by representatives elected by people. But can you today say, with some kind of a responsibility, that if a common man, I give you the example, if an individual is illegally detained, can his relatives have a remedy of going to the member of the parliament or the member of the legislative assembly to seek redressal of his grievance? Answer is no. Answer is no. Because reason is that maybe due to political reasons or due to local influences, that person is detained illegally. So the remedy of going to the legally elected representative elected by us is also not available. And that is how the role of the court becomes very, very important, or role of the legal system becomes very important. Now, today's debate should be on one basic issue: whether the courts have performed the role which was expected to be played by them, or whether courts have performed to the expectations of common man under the Constitution of India. Because when India, till 26th of January 1950, all the courts which were functioning, they owed their existence to the earlier laws, maybe latest patent, maybe High Courts Act. After 26th of January 1950, all the courts are established under the Constitution of India. So it is their duty, their fundamental duty, to ensure that Constitution of India is effectively implemented. Now, when we talk about judiciary, because basically we are discussing the place of judiciary, where the judiciary stands. Now, those usual issues are there. There is a huge pendency. Now, pendency of cases in our trial and district courts is more than 5 crores. And many of those cases are criminal cases. If you see the statistics on National Judicial Data Grid, during last few days, the pendency of Supreme Court has touched 90,000. Well, last about 7 to 8 years, it was between 78,000 to say 80 to 83,000. Now we have gone up to 90,000. And I gave you example of the high courts, where high court judges have 1,000 cases on the cause list. Even it is difficult to deal with 100 cases every day. But we have 200, 300, 400 cases every day. And then the other issue which arises is about the quality of justice rendered by our courts. And if the courts are not able to deliver quality justice, what are the reasons where we have gone wrong? That's the issue which we have to consider. Then there is another issue which is now being flagged. Whether it can be said that the courts are creating obstruction in the way of good governance. Whether courts have become obstacle to development activities, as we call it. So this is also an issue which is now recently flagged by many, and that issue also requires consideration. As we are going to have a panel discussion, I'll stop within few minutes because that's going to be a very important part of today's function. What I believe is that notwithstanding a government which has political legitimacy, notwithstanding the existence of judiciary and the vast powers which judiciary is capable of being exercised, whether those powers are exercised or not, that's a different thing. The question is whether citizens are doing their own duty. I always say this because I am repeating it for the benefit of the young students who are here. I have fundamental right of freedom of speech and expression. I have my fundamental right under Article 25 of keeping faith, or my religious rights under Article 25 and 26. But what we forget is that every citizen has duty to abide by the Constitution. Therefore, when I have freedom of speech and expression, it becomes my duty to ensure that I respect the freedom of speech and expression of the others, or I protect that freedom of speech and expression of the others. Unless this happens, unless the citizens decide to follow law, I don't think that even courts will be sufficient to check the so-called legitimate governments. And it's not about law not being followed by those who are not literate. The real issue is that those who are literate, those who are affluent, they are not following law. Go to any city in India, you will find that rules regarding traffic are observed in breach. The rules regarding town planning are observed in breach. Now we have laws which protect environment. We have noise pollution rules. Now how many educated citizens ensure that noise pollution rules are implemented? How many citizens do their fundamental duty of protecting and conserving environment? How many of us go and protect our rivers and sea and lakes? We allow these sources of water to be contaminated in the name of religion. So the real issue is when we think of the political legitimacy and the place of courts, and when the subject means that what is the significance of place of courts when we have politically elected or legitimately elected government. And obviously what we are going to discuss is whether the courts are doing its duty. In my view, as a citizen, I feel that it is not sufficient for the courts to do their duty. Now time has come after 75 years of existence of Constitution to ensure that citizens perform their duty. We are short of judges, we are short of judicial infrastructure, so courts are not going to be sufficient to protect our rights. And this is something which, the students of law or young law graduates, this is something which this mantle must be taken up by them. It is their responsibility to see that we become more legally literate and we start following the law. Forget about ideals of the Constitution, following the basic law. So we need to have change of approach. And therefore, even you must have read the speeches of Dr. Babasaheb Ambedkar in the Constituent Assembly debates. The last speech he indicates in so many words that Constitution has given us democracy, but it is up to us to see that democracy survives, the Constitution survives. And therefore, when we discuss this issue, we have to remember that, of course, the courts have to perform their duty, but the citizens must perform their duty. And this is how we must look upon this problem. I thank Professor Preetham and his colleagues for giving me this opportunity. And now we can start with our panel discussion.
Thank you, Justice Oak, for, I think, shining the light on certain things that often go unnoticed, which is the importance of trial courts and the rights of ordinary people, which mostly go to these courts, and also for pointing out the importance of institutions in a time of what many academics have called post-democracy, which is the apathy of citizens towards several of these important issues. Before we go to our panel, I would first like to invite Professor Faizan Mustafa to offer his comments as chair on Justice Oak's lecture.
Good evening. Thank you very much, Preetham. What an excellent lecture and treat we had from Justice Oak. And it's an honor to speak when Professor Gurpreet Mahajan is here. All of us have understood and read multiculturalism through her writings. Now, I have a difficult task to make comments on a lecture which is very settled, given by one of the best judges of our times. I am reminded of Edison, who said, "To be perfectly just is an attribute of the divine nature. To be so to the utmost of our abilities is the glory of man." Now, this is the apt description of nature of judicial function. And whenever I see and hear Justice Oak, I'm also reminded of David Penick's book, Judges. The qualities desired of a judge can be simply stated: that he be a good judge and that he be thought to be so. Justice Oak fulfills both the requirement. He is a good judge, and we all have great admiration for him. Now, teachers are one in the habit of to be, if they're real teachers, to be more blunt and less diplomatic. That's how, Chanakya was able to speak truth to Dhananand in Magad. The whole question is, this evening, that how come unelected judges should be able to overturn and overrule decisions made by the elected representatives of the people. Because the legislature, the parliament or the state legislatures, and the executive, they are rightfully said to be representing the popular will. And judges definitely don't represent the popular will. But I am reminded of a conversation about which historians differ. Some say that this conversation between Stuart, King James I, and Chief Justice Cook never took place. But this is how it went, that the king wanted to say that he can decide cases himself. And the archbishop was having some dispute with judges, and he said it's better if instead of judges, the British monarch himself decides. Now, Chief Justice opposed it and said, king cannot decide. Then king replied, James I, that he thought the law was founded on reason, and that he and others had reason as well as the judges. Cook then said, according to the account in the 12th report, that true it was that God had endowed His Majesty with excellent science and great endowments of nature. But His Majesty was not learned in the laws of the realm of England, and causes which concern the life or inheritance, or goods or fortunes of his subjects. They are not to be decided by the natural reason, but by the artificial reason. And the judgments of law, which law is an act which requires long study and experience before that a man can attain to the cognizance of it, and that the law was the golden metwen, and the measure to try the causes of the subjects, and which protected His Majesty in safety and peace, with which the king was greatly offended, of course. And he said, then he should be under law, which was treason to affirm. Now, this is the reason why judges should have powers. Because if they exercise their powers properly, then there will be peace. The king would also stand protected. And because they are trained in a particular kind of reasoning which others are not trained in. Now, within the political scientist, for long there has been this whole debate that this idea of separation of powers is a kind of an illusion. In parliamentary democracy, Parliament does not control executive. As all of you know, which bills will come before Parliament? The government will decide. What would be the duration of House? Government will decide. And you know, lately, Parliament and state legislatures are passing laws in 5 minutes, in 3 minutes on an average. The number of days they sit is, with every passing year, getting reduced. And most of the time when they are having sessions, they are just opposing each other rather than doing the legislative business. The point I'm trying to draw home is that there is a core function of each branch. The other branch is not supposed to interfere with the core function. But at times, if the other branch is not working well, probably it has to interfere sometime. The problem which many democracies are facing, particularly in Latin America, in number of Asian countries, is not whether the judges who are not elected should have power to sit on judgments of people's representatives. The challenges to which His Lordship made a passing reference, you were given a task. Ultimately, you can't be saying that this whole constitutional system has come into being without some settlement. Now that settlement has a popular approval. Of course, Indian Constitution was never referred to us in referendum. Of course, our representatives, directly elected representatives, were not sitting in the Constituent Assembly. Nevertheless, by participating in elections after elections, people of India have impliedly endorsed this Constitution. And in terms of representative character, the Constituent Assembly had representation of almost all sections of our population. So we, people, agreed to some kind of arrangement. That is, in my opinion, is the legitimacy, and judges too have that popular will in support of their powers to sit on judgment. So we made an agreement that, okay, you will make laws, and you will execute laws, and you will make sure this power itself has come from the people, who are the sovereign, that you will ensure that legislature and executive does not transgress its limits. People's rights are not violated. Supremacy of the Constitution is maintained. That is a task which has been given to them. The problem which we are facing is that are judges doing enough to protect the democratic character of the Constitution? There is a difference between majoritarianism and democratic governance. Justice Oak rightly made a reference that elections, and look at that, in most places you will not have more than 50% people even voting. How governments are formed, rarely a government has support of 51% people. Because you have a multi-party system, if you have about 37, 38% of votes, you will form a government with big majority. Look at the current Bihar election. The highest number of votes, about 23 point some percent, went to RJD, but it got just about 25 seats. So whether the elected government really represents the will of the people is also questionable. But assuming that this is a system which we have, in that system, we have to make sure that, as Lord Acton said, power corrupts, and absolute power corrupts absolutely. The judges have been given the task that they make sure that the governments of the day do not go against the Constitution. How come our courts are not even reacting, even though they are said to be more executive-minded than the executive itself, when somebody says that Supreme Court is using power of 142 as a nuclear missile. Or another politician says that the Supreme Court is leading country to a civil war. This is dangerous, in spite of all the judgments they have given, which have gone in favor of the government. So judges are also people's representative because of that covenant, which is called the Constitution of India. They hold office not during the pleasure of president, but during good behavior. And their good behavior is that they stay firm, and they stay independent, and they remain committed to the Constitution. What is really happening that word over, there is weakening of democracy which is happening. So many books have been written how democracies die. Are judges contributing to that weakening of democracy is the question. The question today is not that how can unelected judges sit on judgment on the decisions of the elected representatives of the people. Are judges themselves, by not asserting their power, weakening the democratic governance in itself? What are they doing to ensure that various constitutional agencies which conduct the election remain independent? How come when a judgment of a Supreme Court within 2 weeks or so is overturned through an ordinance, Supreme Court refuses to even examine it or put any stay on it? I understand that in the judgment itself, Justice Chandrachud has opened a window that, okay, our observations are till the Parliament comes up with a law, and Parliament is free to come up with any law they want to bring in. But this is the real challenge, which I believe we need to understand. The other issue which which a reference was made by Justice Oak, this whole talk of fundamental duties and fundamental duties being more important than fundamental rights. Liberal constitutions in the world, democratic liberal constitutions, don't have a provision of fundamental duty. Fundamental duties are the relic of socialist constitutions, authoritarian constitutions. We did not have it. We criticized 42nd Amendment for inserting words secular and socialist, but we celebrate insertion of fundamental duties. Indian Constitution, even Mrs. Gandhi, at the peak of her power, could not include fundamental duties within fundamental rights and make them correlative in the typical positivist sense that, you know, as you can't have a father without a son or a wife without husband, you can't have a right without a duty or a duty without a right. We don't have that kind of thing. In India, traditionally we were saying that we are a kartavya pradhan desh. Even in Mahabharata, Arjun was saying that he was not able to convince Arjun in the name of a right to the kingdom. It is only when he said it is your dharma to fight your own cousins that he was able to convince Arjun. Therefore, to me, we should not confuse majority government with democratic governance and equate periodic electorate return of the will of the people. If integrity of electoral rolls is controversial, if the election commission is not independent, if freebies are offered before elections, if there is use of money power, muscle power, religion, and what Ravish Kumar says, Godi media, then of course, the government which gets elected may not have the same kind of legitimacy which in a typical classical democratic governance a government would have. The idea is if you are really democratic government, then between judiciary and you will have a greater right because you represent people. Democratic leaders don't like judicial review. Even Pandit Jawaharlal Nehru in the Constituent Assembly itself said, if we go wrong here and there, Supreme Court can point it out. But if it come in way of sovereign will of the people, represented by us, then we appoint judges. And then Mrs. Gandhi, at least twice, indulge in what is said to be the supersession of judges. Going back to the question, how do people look at court? The legitimacy to the court's role comes from their independence. Independence of judiciary is not the right of judges. It is the right of the people. We want you to be independent. If long, his lordship was talking about bail, long adjournments for bail, people not getting bail for 5 years, 6 years, trial also not taking place. That's not good. Democracy is all about freedom of speech. Everybody should have a right to speak. The Constitution talks of making of new states, bifurcation of states. 2 days ago, Supreme Court was talking about dialogue in the presidential reference between the governor, who is by and large agent of the center, and a democratically elected government. His silence, as Pratap Bhanu Mehta would say, is also part of a dialogue. He can simply sleep over for months together, and a democratically elected government won't be able to do it. In Article 3, the only power a state legislative assembly has when a state is going to be bifurcated, expression of opinion. We even deny that. And such a major issue, Supreme Court did not answer in 370 judgment. Number of cases, of course, governments win cases. There is no harm if, by and large, there is presumption of constitutionality. We presume that legislature has done its homework. I'm just finishing, Pratham, just 2 minutes. But look at 6A judgment. Assuming government had opposed 6A, probably the judgment would have gone the other way around. Because there are people who are saying that the citizenship, even in Assam, should be determined on 19 July 1947 or 1st March 1947, not 25th March 1971. Sealed cover is back, the whole Vantara thing. Review is accepted if government is interested. The court does not bother about its own judgments. No error in the Sabrimala judgment was pointed out. Yet the review was accepted. The law is very clear that Muslims cannot be scheduled caste, even though this is a discrimination solely on the basis of religion. But at least as the law stands today, Muslims can be scheduled tribe. If there is a Muslim who is a scheduled tribe and it is his property, why can't he create waqf? And therefore, Supreme Court's judgment, this interim order, is disappointing on more than one count. What I am trying to, equality of marriage, one Shakti. An excellent judgment from his lordship, getting overruled. And then I will close on this. One feels sad to see the justification of judicial powers comes not just keeping government in check, giving justice to ordinary people. For years, I have been thinking that Muslim women have a better chance of success in our courts than the Hindu women. In number of cases like this, if they don't put sindoor, then it is cruelty. Husband is entitled to divorce. If they say that we will not live with mother-in-law, they say it is cruelty. And the case which comes to my mind, that if you are a Hindu issueless couple and you die, the property of husband will go to husband's heirs, but the property of wife will also go to the husband's heirs. And in this case, husband died due to snake bite, Om Prakash case I am talking of. The in-laws threw her out of matrimonial home. She was educated by parents. 42 years in-laws did not return, did not ask her welfare. She becomes a school teacher, gets gratuity, pension, constructs house, makes some savings. And on her death, Supreme Court does no judicial activism and say we are bound by the legislative scheme, and the property of this lady was given to in-laws. The presidential reference, does it really strengthen democracy? Who represents democracy? Governor or the chief minister who is elected by the people? And therefore, I think that we have to see that in addition to promoting constitutionalism, ensuring supremacy of the Constitution, are judges really adjudicating with fairness? Thank you very much.
Thank you, Professor Mustafa. I think the comments that you have made will really fire up our panel discussion, which is to follow, and for also pointing out that judges have a different kind of democratic legitimacy, but you have also set the bar very high for how that legitimacy is to be earned by pointing out to all the problematic cases. We would have actually loved to have a Q&A session now, but it's already 5:30, and we do have a 10-minute break with tea and snacks being served outside. So I think what we will do is we'll take the 10-minute break now. Everybody, please, you're invited to join us for tea and snacks outside at the lawns. And then we reconvene in 10 minutes, maybe at 5:40, for our panel discussion, where Professor Gurpreet Mahajan and Justice Muralidhar, who's already here. Sorry, Justice Muralidhar, we were a bit late in starting. People were stuck in traffic. No, and okay. So we are going to take a 10-minute break and come back. I hope that is okay with you. So, that's fine. That's yes. Fine. So we'll message you as soon as we reconvene here. Yeah. Okay. So we take a break now for tea, and we reconvene in 10 minutes. Thank you.
I just
joined us. Our panel today will continue our discussion on the idea of political legitimacy and the place of courts. I don't think after hearing Justice Oak and Professor Faizan Mustafa, I need to introduce the panel. The issues are already out and people have been discussing it over tea. Let me first then invite all our panelists to join me on the stage and I'll introduce them. So Justice Oak, Professor Mustafa, Professor Gurpreet Mahajan, please to come and take seats on the stage.
Do you have a certain order?
No. You can take any. Please. Yes, I'll join you here. Maybe. Yeah. So, joining Justice Oak and Professor Mustafa, who I've already introduced and all of you know, are Professor Gurpreet Mahajan, who's former professor at the Center for Political Science at Jawaharlal Nehru University, and is one of India's most noted political philosophers whose work focuses on democratic theory and issues of differences and discrimination. She has written extensively on secularism and multiculturalism, minority rights, and integration and equality in civil society. Amongst her many publications are Explanation and Understanding in the Human Sciences, Identities and Rights, Aspects of Liberal Democracy in India, The Multicultural Path, Issues of Diversity and Discrimination in Democracy, India, Political Ideas, and the Making of a Democratic Discourse. So welcome, Professor Mahajan. It's a pleasure to have you with us. Justice Muralidhar is not able to join us in physically, but he is here online, and we are very grateful that he has spared his time. And those who are lawyers, I don't need to introduce him, but for those who are not, Justice Muralidhar is a senior advocate at the Supreme Court of India and former Chief Justice of the High Court of Orissa. Unfortunately, he was not able to make it in person, but you can see him on the screen. He is known across the world as one of India's most fearlessly independent and empathetic judges. As a lawyer, he championed causes of social justice and legal aid and has been instrumental in bringing to the center stage questions of access to justice. He is also the author and editor of several works on the Indian legal system, including most recently an edited collection of essays on 75 years of the Supreme Court of India. Before I start the panel, may I request everyone to kindly keep their mobile phones on silent, and if they are talking, keep their volumes a bit low. There can be disturbance. It's an auditorium where the acoustics are good. We can hear everyone. So, Justice Muralidhar, if you can hear us, we are going to start the panel discussion now.
Yes, I can. I hope you can hear me.
He will be able to hear us on this mic. We can hear him, but for him to hear us, we'll have to switch on these mics.
Switch on the mic.
Yes,
That's right.
there's a red button, tiny button at the bottom, and we just press that. Do you find it? Yeah, okay. Yes.
So he can hear us.
Yes, I am mute.
Maybe I'll start it off by a question which is open to all the panelists, and I would prefer if Professor Mahajan started, with her answers first. And Professor Mahajan, and I think then in this order we could follow, and then at the end Justice Muralidhar. It is usually thought that democratic legitimacy lies with elected bodies, and also in social movements, which then generally sometimes turn into political parties. But according to you, what are the moral, ethical, or political values that make democracy desirable and as a form of government? And can these values be captured by unelected bodies such as courts or other commissions?
First, thank you very much for this invitation to be part of, I think, the leading legal minds of our country. So it's a great pleasure and honor to be part of this. Let me begin by sort of saying something about democracy, and I think democracy is valued for me for three reasons. It comes with the promise of a limited government, limited in the sense that it would not be acting through arbitrary decisions, and those decisions or actions of the government are therefore open to scrutiny, and we leave it open, scrutiny by whom. So I think that's one. Limited government is one element that is very important and makes democracy desirable. The second is it gives people a voice. And that voice has to be read in terms of there have to be multiple avenues by which or through which they count, not merely in elections. Elections is important, but there have to be many other ways in which their voices are heard. Again, I will leave that. The third, of course, is democracy is valued, and I think the great value in this is that it stands up for people's freedoms and liberties. Again, I think none of these we can talk about it in detail in the sense which freedoms and liberties, but we'll take it at that. And this is on the procedural side, and I think in terms of the value, the most important value for me which democracies come with the promise of is the idea that you will not be judged and your life will not be determined by the place in which you are born, in this sense, your family, your kinship, your whatever. So I think it comes with the promise of what I call social non-discrimination, so that you have to work in terms of values that it's going to promote, you are going to work for that. So I think if one looks at democracy in this sort of way, then it would be, from my perspective, evident that getting the mandate from the people is an important part, but it's a small part of what democracy stands for. And more important thing is whether the mandate, people who have the mandate actually function in accordance with, and these things have come up already in the talk and the comments, they abide by constitutional norms and values that are there, because that's one way Constitution not only lays down what the institutions should do and how they should function, but also the values that should guide the action of the courts or action of any body, executive, legislature, courts, whatever it might be. So I think there is that particular element. This also brings in the idea then that it has to be by rule of law. There has to be, in that sense, if actions are arbitrary or not fulfilling the basic rights or concerns of justice or equality or non-discrimination, which is what I prefer to call it, then you would think in terms of, I think, other institutions coming into play, whether it is for the sake of participation of people, more than just social movements. You can think in terms of various avenues for consultation, for bringing them into lawmaking and so on. So I think in that sense, legitimacy, and I would like to use the word democratic legitimacy, is far larger than the idea of just political legitimacy. Democratic legitimacy rests on all these boxes being checked. And I think in that sense, it would not lie only with elected representatives. It will lie also with them, but it will lie to large measure in terms of how they perform and how other institutions, which are forums for discussion and deliberation, perform, how, in this case, let's say courts, which are expected to review and to see that the constitutional norms are upheld, do their work. So I think democratic legitimacy lies far beyond elected representatives.
Thank you. Thank you for that. Justice Muralidhar, are you able to hear us?
Yes, please, of course.
So maybe because Professor Mahajan has spoken about democracy being the voice of the people, not being expressed only through elections, but through other institutions also, and you have recently come out with a book on 75 years of the Supreme Court. Perhaps we could hear from him first on, in your assessment, whether courts are institutions where people actually find voice.
Thank you, Professor Barua. First of all, it's such a pleasure to be here among my friends, my dear friends, Justice Oak and Professor Mustafa. I'm sorry I'm having to strain your necks to pretend to see me, but it's a pleasure. And Dr. Mahajan, I mean, I've heard so much about you, and it's always a pleasure listening to you. I've also read many of your writings. The question that you framed is extremely relevant for our times. There is a popular misconception that courts, being unelected bodies, cannot plausibly have a check on what other organs of state do. This is a general misconception, and as Dr. Mahajan was rightly pointing out, courts perform a very important task. They provide democratic space for deliberative democratic practices. Those familiar with the writings of Professor Roberto Gagarella will immediately recognize that in the court space, there is a contestation. And it's more stark in the Indian Supreme Court. If anyone has watched the proceedings in Justice Oak's court, for instance, the various competing interests in a public interest litigation case get actually played out right in front of the court. And the court is compelled to take into account all these competing interests. So in a sense, therefore, the shaping of our democracy is facilitated to a large extent by the deliberative democratic practices. Am I still audible, please?
Yes, you are audible.
Yes. So if you ask me, because the question that you have framed, one general question for all of us, what are the moral, ethical, or political values that make democracy desirable as a form of government, and can these values be captured by the institution and processes outside of elected bodies? I've just briefly mentioned to you how much of these values of deliberation, discussion can be captured by courts by providing space for that. But there are other values which I think are very important for all unelected bodies also to subscribe. So I was briefly looking again at the preamble to our constitution, and two words that struck me immediately is the words justice, social, economic and political, in that order. There is a lexical order, and it has, I think, deliberately been inserted in that order by our constitution makers, placing emphasis on social justice. And it ties in with what Dr. Mahajan was talking about, social democracy, because Baba Saheb's the interventions in the Constituent Assembly reflect his anguish about social democracy. He says we might be able to achieve political democracy to a certain extent, one man, one vote. But one man, one value in the social sphere is what we are going to be struggling for. And those two words, social justice, ties up with what we say in the end of the preamble, fraternity assuring the dignity of the individual. It's not mere fraternity, but a fraternity that assures the dignity of the individual. So what we have in our constitution are some provisions which are very unique, which acknowledges this particular aspect of dignity of the individual. If you take, for instance, Article 15, Sub-Article 2, where we threw open bathing ghats, places of entertainment, all of that to the public. So we implicitly recognized horizontal equality, not just vertical non-discrimination, but horizontally, that is citizen to citizen, person to person. And this is actually the vision of the constitution makers, Article 15. Then we talked of affirmative action. So this was not, ours was not a democracy which was a majoritarian democracy. Ours was a democracy which was supposed to accommodate a plurality of interests, a diversity of views and opinions. And inclusivity was a very strong running theme in our constitution. So both affirmative action and as a tool of affirmative action, reservations, recognition of the rights of minorities to establish their own institutions, all of that, the whole core of Part 3, if you look at it carefully, it is a validation of this social democracy that we are talking about and horizontal nature of that social democracy, which we have to keep working at. So when we talk of unelected bodies, which is also including the judiciary, we have to subscribe to these essential values, and that I would put right on top the value of human dignity. So whether we are, let's say, religious bodies, we are unelected bodies, you have large followings of godmen in our country, you have large assemblies, you look at a satsang, you'll find till the end of the last line, it's overflowing with people, right? Immersed in their religious practice or the chant or whatever. In those kinds of bodies, how much do we subscribe to these constitutional values? This is something that we have not bothered to really ask so far. For instance, let's say dowry prohibition is something that the parliament has enacted way back in 1961. In how many of our religious bodies will you find a religious preacher telling his audience that we should definitely abolish the practice of accepting dowry in our marriages? How many of our religious preachers will actually say Article 17 in our constitution talks of untouchability? We must embrace this constitutional value of untouchability. And we, within this religious congregation, should not practice untouchability, should not practice caste discrimination. See, it is only when that unity of perception by unelected bodies of these constitutional values happens that we can make real progress towards social democracy. Otherwise, we'll be leading dichotomous lives. As a judge, I'll be talking of non-discrimination in my court. I'll be talking of non-arbitrariness. But when it comes to my daughter's marriage, as a judge, I will say, no, my daughter can't marry someone outside her religion. My daughter can't marry someone below her caste. So I will be leading dichotomous lives. So even if people in positions of power, even in an unelected body, if we don't subscribe to the basic constitutional values, then this social democracy that is promised in the preamble to our constitution and in these various provisions, like for instance, exploitation of labor, Article 23. How many of us, the way we treat the domestic help in our households, how many of us actually subscribe to these values? How many of us respect the dignity of that individual? So this is a very, very serious question that you've asked, a very, very timely question, which makes us introspect and reflect, even in the 75th year of our constitution, what in this constitution do we value most? What in this constitution which we will not compromise on? And if we pick up this one element of dignity of the individual, make it the centerpiece of our constitution, then the whole way we conduct our lives, our individual lives, that will get transformed in the first place. And when we transform at an individual level, we expect the transformation to expand to the other levels. So I think your question on what is the extent to which these values will inform the actions of unelected bodies is absolutely right. I just want to end by saying there's a common misconception that democracy in our country is about numerical majority. That is far from true. The day that electoral majorities in our country do not subscribe to the constitutional values, they will simply become electoral autocracies. And this is what we have to guard against. We don't want electoral autocracies where autocracies come into power through the process of elections, and we are then stuck with all these non-democratic practices which pass off as legitimate because of the so-called mandate of the people. And that is where the courts have to come in. That is where the courts have to perform what we call counter-majoritarian roles. And being counter-majoritarian is not anti-democratic. Being counter-majoritarian is actually consistent with being democratic in our country. I'll reserve my comments for the others. Thank you. Thank you very much.
Thank you. Thank you, Justice Muralidhar, for your comments. Professor Mustafa, traditionally lawyers would say that constitutionalism and democracy are two different things, but we have here two panelists who seem to be also saying that they are, there is a big overlap. But over to you to answer the first question.
No, I entirely agree with the...
Want to use this?
I entirely agree with Professor Mahajan and also with Justice Muralidhar. The whole idea that we wanted to be a democratic country, we were conscious of the fact that we are conferring powers and too much of power. Of course, we don't believe that our parliament, like British parliament, can do anything except to make a man a woman or woman a man. So, supremacy of parliament is not there. Nevertheless, this is a body which represents the will of the people. But as Justice Muralidhar was saying, that the whole idea is that democratic government should not become majoritarian, so counter-majoritarian. How do you protect the rights of the minorities? And I would also take it forward, this whole idea that, to which Professor Mahajan was saying, idea of limited government, that everybody will have limited power. Nobody will have arbitrary power. I am surprised, in fact, in the presidential reference on a discussion about discretion, there are judgments of the court. Court itself has said that discretion does not mean absolute power, that you can act on your whims and wishes the way you want. But more than that, to this whole idea of dignity of individual, when you get laws like this, for instance, which religion I follow, it's absolutely private decision with which state should have nothing to do. Now you have laws in some 12 to 13 states. They say that I have to write to the district magistrate 1 month in advance that I propose to change my religion. Then all my details will be put on a display. So you are making me vulnerable to lynching. Why state has anything to do with absolutely private decisions? Similarly, in terms of what one eats, this should not be, state's concern. This morning I was reading in newspaper 3 people being given life imprisonment in Gujarat law. So what are we doing that there is a central law, now you have this BNS, which prescribes punishment depending upon the gravity of offense. Now life imprisonment we give when somebody has killed a human being. So dignity of individual is undermined. Governments are not kept in control because judiciary concedes. I was just discussing during break, there is settled law that the provision of oath cannot be the source of power. Now in the presidential reference they are saying that just because governor is taking the oath to preserve, protect and defend the constitution, then he can do anything much more than the ministers. Then the president of India is also taking the same oath. Are we going to say that the president of India will have more power? Just look at the representative character. If you compare prime minister with president, prime minister is the leader of the lower house of the parliament. At times, he may not have majority. You had Dev Gowda with just about 27 MPs and then others were supporting. But at best, he would be a leader of 272 in one house. And in democracy, your powers would depend upon your representative character. I'm taking the same argument forward. So the President of India is elected by both the houses of parliament and also by all the state assemblies. Then he should have more power, if that is our argument. So what I'm trying to say that if on constitutionalism we are not doing well and we are allowing what Professor Mahajan was saying, elected autocracy kind of a thing, then ultimately we are moving away from the ideals of democratic governance. Some of the judgments which have come, remind me of that Urdu couplet, one after another. एक दो जख्म नहीं है, जिस्म है पूरा छन्नी, दर्द बेचारा परेशान है, कहाँ से उठे?
Now on that, let me ask Justice Oak, because both in his comments to the lecture, Professor Mustafa pointed it out, and now Justice Muralidhar also said that there is democracy in courts because they're deliberative, and then of course there's this question of human dignity. But in your experience as a judge, have you seen that these democratic practices of deliberation are actually happening in courts, or is the criticism of the kind that comes shows that it is only a promise which we haven't been able to, judges haven't been able to fulfill?
About democratic functioning of the courts. Now, I come from Bombay High Court. At least first 10 or 15 years I was in Bombay High Court, 15 years, 9 months. Now, where does democracy figure in the court? In administrative decisions. Now, I have seen in Bombay High Court, our full court meetings taking various administrative decisions sometimes used to go on for three hours or more also. So, those deliberations take place. Only one thing which, of course, I respect the views expressed by all the three. I mean, mostly I agree. I am not even a student of political science. I'm basically a lawyer, and I can say that I know few laws. But what is the idea of democracy? Idea of democracy is people elect the government by process of election. And then democracy comes into action, that there is people vote, some people get elected, they form government. But whether democracy contemplates that everybody who holds important positions, they must be elected. I'll give an example. I'll come to that, judges getting elected a little later. Today there's a lot of controversy about election commission, appointment of election commissioner. It is openly said that election commission is biased and all. I am not into that. Imagine what will happen if somebody says that elect an election commissioner through popular franchise. What will be the outcome? Who will become election commissioner?
Same political parties, people will become.
Right. So, and we talk about the judges. I remember I was a lawyer just before my elevation. In one of the small district places, there is a law college, there was a seminar. And there are many politicians. There are no judges. I was a lawyer at that time. So same hypothesis was canvassed by the politician. That, we represent collective wisdom of people. And one or two individual judges, they sit in the High Court and they strike down our laws. So why judges can't get elected? So question which I asked in that, I was a lawyer at that time. I said, let us imagine that there will be, let judges be elected. Now who will elect the judges? Whether Parliament will elect the judges, parliamentarians will elect the judges, or people will elect the judges. So when we talk about democracy, it's not as if that every authority which is part of the governance, that should get democratically elected. And in a lighter vein, I want to say this. If there was to be a concept of election, judges getting elected, perhaps I would not have become judge at all. Maybe Muralidhar may not have become judge.
No, but sir, this democratic, election process may not be there, but instead of Chief Justice being consulted, of course, there is now record that during Pandit Nehru, Chief Justices were able to veto choices of the government, which doesn't happen often now. But now when we say that 1+4, so this is a part of some democratic process, deliberative process, that it will not be one individual which will decide. But if you look at legislature, whips are issued. If you vote or speak against your party, then you are going to lose membership. So the house which was supposed to be the deliberative house is no more deliberative. That is a problem.
So I wanted to come back to, because this question of election of judges has come, and maybe, I don't know if Justice Muralidhar, I had prepared this question for you, but if you want to take this, that there is this question that issues that Professor Mustafa spoke about earlier also in his speech, maybe questions of citizenship, questions on personal laws, questions relating to the environment, religion in public life. Parliaments claim that they represent the ideas of people, and election is the only way in which this representation can be ensured, and therefore they have legitimacy. What legitimacy can judges claim to saying that, no, we have equal legitimacy in working with these issues which are moral and political issues, though maybe mediated by the Constitution? And often we get this that, oh, that's judicial overreach or that's judicial activism. So is it possible to draw a line somewhere and articulate the legitimacy of courts in deciding such cases?
Yeah, I think at a very fundamental level, the very provisions of the Constitution, I think, which you mentioned, Professor Barua, in your opening remarks, Article 13, Article 32, Article 226, laid the broad contours of the powers of judicial review. And ours is one of those constitutions as a principle of checks and balances, where the courts are asked to perform this judicial review of legislation by keeping the legislation alongside the Constitution and finding out whether there are any provisions of the statute or the statute entirely which violates the provisions of the Constitution. We've extended it to even constitutional amendments. So as a student of law, there should be no difficulty at all in recognizing that one of the functions of the courts is to test the validity of laws enacted by Parliament. So when I hear, even people holding constitutional positions say who are the courts to strike down laws enacted by Parliament, they're forgetting the very structure and scheme of the Constitution. So first, I want to lay that very fundamental conceptual part as a foregrounding to my later remarks in this, in answer to your question. If you look at the history of our constitutional evolution and of the courts, you will find that at various points there has been a dialogue between the Parliament and the courts. Why do I say that? I pick up three instances. If you look at Lakshmikant Pandey, the decision that laid down guidelines for adoption of children, you will realize that for a long number of years now, that has become the standard template of guidelines that are to be followed by governments after governments on adoption of children. It was laid down by the courts. If you look at Vishaka, the guidelines laid down by the court became the template. 10 years later came the legislation. If you look at J.P. Unikrishnan's case on right to education being recognized as a fundamental right, the insertion of Article 21 capital A followed more than a decade after the judgment in Unikrishnan. And then, of course, you have the Right to Education Act. So, and you look at the Nalsa judgment, rights of transgenders. The legislation comes some years after the judgment, which means the trigger for all these legislative acts have come from the court, despite the criticism, the popular criticism that courts can't be making laws. This is in a sense Parliament acknowledging that it failed to do something that was required to be done. The court has taken the lead. The Parliament appreciates the lead taken by the court. The Parliament follows by the court. Let's take the instances of an election, Assembly, having to disclose in an affidavit their wealth and their criminal antecedents. If you recollect, the trigger came from the court. When the Parliament tried hurriedly to pass an ordinance to overcome that, the court struck back and said, no, our earlier judgment is correct. And that today is the law. You do have in elections candidates efforts disclosing their wealth and criminal activities. So, you've had this kind of a dialogue where, for instance, the court went to the park.
Yeah, Justice Muralidhar, I think we are losing you there. Your voice is breaking. So maybe... bad instances of... Yeah, I think we have lost him there. So, Justice Muralidhar, just taking on from what you said, I wanted to put something to Professor Mahajan here, that you have been a long watcher of democracy. If courts are doing such wonderful things, why is there increasing hostility to courts across the world? Whether it's in the US, we have recently seen bastion of democracy. Even in India now, court is being called a super parliament. Parliamentarians have said that courts legislate without any accountability. So in your reading, why do you think there is this growing hostility?
Actually, I think the Indian and the American case is not really comparable. Not only because how judges are elected and the position they hold and so on. A lot of the time in America particularly, when they questioned the authority of the courts, it's coming from two traditions: republicanism as a political theory tradition and communitarianism. These are the two groups of people who are saying that courts represent just a few people and they don't represent the will of the people. But who represents the will of the people and how is the will represented? I think on that they say something also very important, and which Professor Mustafa mentioned, that when you're thinking of democracy, of course there are all these issues about, in our case, 30%, 40%, and you become the majority government. It has always been there from the beginning. For over 75 years, this has been the case. Forget that aspect of it. But the fact is, democracy is, and the will of the people can't be expressed just once in 5 years. So there have to be avenues for deliberation. You mentioned democracy, deliberation comes in always. So deliberation. but also for critical moments where people can express their point of view, be consulted. There used to be earlier lobbies, there used to be consultation in the select committees, invitees were there, there's civil society roles that are there. So I think there is this particular element that we need to sort of bear in mind out there when they are thinking in terms of saying, well, courts should stay off. They are thinking that these are matters which citizens should deliberate on at various levels, from the local neighborhood level all the way to the top. So these decisions will be taken in terms of continuous deliberation. But if we don't have deliberation spaces, even the space that we have, and this has already been mentioned, so I don't want to repeat it, because the number of hours that the parliament spends discussing and debating, so the avenues for deliberation are fewer. And I think we are also living at a time when you're thinking of populist democracies, and I think there's some difference between majoritarian and populist democracies, because one element of the populist democracy is that it assumes that they are getting the power to rule from the people, so they can bypass institutions and procedures which are meant for deliberation, for consultation, and so on and so forth. So under those kinds of circumstances, you have to find spaces where people can express their point of view, to look for alternatives, I can't say they deliberate, but certainly in the court they have an opportunity to present alternative arguments. And I think that's an important element in terms of being able to present, to be heard. That's another way in which you are heard. It's another matter that who can go to the court. It's not easy. Number of cases, the expense involved, all that. But still, there is that particular element that is there. And I think that is why there is, even though legitimacy has to be earned by each institution. You may be elected, but you may act in ways which are violative of, as I said, lay down laws, procedures, constitutional values, etc. And even in the case of courts, they will need to justify that they are performing the role of ensuring that the rights are protected. And I think a lot of the time, I would say it's all right for courts to intervene, and they should intervene. But I think as defenders of basic rights and values that the Constitution upholds, rather than merely thinking, I think sometimes one needs to make this distinction between what is the policy to be followed and what is the value at stake. And I think you mentioned this case of the recent judgment, the role of the governor and so on. I thought before the court you have a very important function of balancing values. So how do you balance elected representation with the appointed executive, but also the basic structure value of federalism with others that are there? So I think those are the important tasks which have to be performed by the court, and that is what gives it space and I think legitimacy. How well they perform on that will determine the faith people have in them and see how legitimate they are, rather than merely for the sake of being elected.
So Justice Oak, I wanted to come to you on this question of judicial legitimacy because, for example, legal scholars have often said this. Lon Fuller said it in a Harvard Law Review article, exactly the point that you made, that citizens can bring in their own proofs before a court. And the court has an obligation to listen. The parliament may not have that obligation, and the court has an obligation to give reasons, which the parliament may not have an obligation to give reasons for its decisions. And as Professor Mustafa pointed out, mostly you stonewall others and toe the party line. But you have been an advocate of judicial reform in many ways. So what do you think are those pressing questions about judicial legitimacy which the court should pay attention to today, and how they could reform themselves to present themselves as a legitimate authority? For example, questions of how the roster is determined or how cases are distributed between judges. These are some of them. But if you could point out a few pressing concerns in your mind of how courts can gain legitimacy.
I'll deal with that, but only a very important point was made by her. When a government gets elected, the ministers or the ruling party can say that the wish or will of the people is that we should get elected. Now, the criticism is that a legislation is made by the legislature, which is democratically elected with the will of the people. What business the courts have to strike down that? So carrying forward what she said, I want to make a distinction. Suppose those who get elected with the will of the people, because they vote in their favor, they come out with a very draconian law, which is completely contrary to fundamental rights or basic structure and all. Can you say that will of the people is that such law should be enacted? Can you say that? Will of the people is represented by electing the government. But you can't say that because elected legislature frames a law which is draconian, that the majority of the population is supporting that law. So that's the distinction which I wanted to make. Now, coming to the pressing issues. First, you talked about the roster. While I was sitting judge, I have said that I have made a distinction between Supreme Court and High Court. In all High Courts, I think without exception, there is a fixed roster. I'll tell you what is the concept of fixed roster. That, see, there are 10 benches. So bench number 1 will take up criminal appeals against conviction. Bench number 2 will take up criminal appeals against acquittal. Bench number 1 will take up PILs. Bench number 2 will take up writ petitions on the criminal side. So when a litigant files a case, the roster continues for a while, 2 months, 3 months, depends on the court, traditions of particular court. So when a litigant files a case, after reading the roster, he precisely knows before which bench his case will go. And in most of the high courts, at least in 2 high courts where I was there, Bombay and Karnataka, you know what happens is there is a roster. So one judge is given bail assignment. Now, if that judge recuses, the Chief Justice, while finalizing a roster, also passes an order that in case A judge recuses, automatically the case will go to B till the time that roster for 2 months or 3 months in force. B recuses, it will go to C. So once Chief Justice notifies the roster that which category of cases will be heard by which bench, even Chief Justice doesn't have discretion. It operates automatically. Registry has no discretion. In Supreme Court, what happens is there is no roster like this. There are subjects assigned to the benches. And if you see on the website of the Supreme Court, that same subjects are assigned to 3 or 4 benches. So, for example, you'll see those subjects that, I'll give an example. Town planning laws, let us take it. If it is assigned to more than 2 benches, then maybe it's a discretion of the Chief Justice or discretion of the registry to place a matter before one of the 3 benches. And that is where I said in my farewell speech that Supreme Court is a Chief Justice-centric court, right? So every new case technically can be assigned by the Chief Justice to the bench which he desires. So to that extent, the pattern which is followed in high courts must be followed in the Supreme Court. So there has to be a fixed roster. So that reduces the manual intervention when it comes to listing. And then other things which Bombay High Court tried, I tried as Chief Justice, that in Karnataka, you know, suppose a writ petition is filed, a bail application is filed. Irrespective of the fact whether those technical objections are rectified or not, there should be a provision that it should be listed, say, on 5th day of filing, 7th day of filing, 15th day of filing. So there is no discretion. Then nobody can say that, you know, because some senior lawyer mentions, therefore that case gets priority. In fact, I tried that experiment in pandemic, which was successful. So irrespective of advocate appearing, a case is filed today, it will appear on the 7th day. So that is also very much required, so that that rules out allegation of arbitrariness in fixing the dates. Of course, it can't be carried further because suppose every case is listed on 7th day of filing, on that day lawyer seeks adjournment, it is for the concerned judge, depending upon how heavy is his roster, he will give a date. So roster and this kind of a auto listing, which again rules out manual intervention. So these are the 2 things. And apart from that, the real struggle before our system is we don't have adequate number of trial and district courts. I always say this with emphasis, I said in my judgments also. In 2002, Supreme Court says that judge to population in India should be 50. 50 per 10 million, per 10 lakh population, 1 million. Today we are struggling at 19, 20 or 21 in some states. Now between 2002 and 2025, the litigation has increased, it has multiplied because there are new laws. Now, unless we have adequate number of judges, 50 is again, according to me, very conservative estimate. Unless we have this kind of a judge to population ratio, the allegation against judiciary, the tariq pe tariq, that's the comment is. See, you go to any metropolitan magistrates court or magistrates court in Delhi, any bigger city. Now these magistrates are supposed to conduct trials. If every day there are 150 cases on their cause list, what is going to happen? How many cases they can take up? So this real issue, no government or nobody has addressed this issue, that we should have adequate number of trial and district courts.
Yeah.
Because these are the courts of common man. We have not addressed that issue.
Yeah.
And it's not simple. You can create posts, but you have to create corresponding infrastructure. So according to me, this is very, very important issue which all rulers have actually bypassed. We need to have adequate number of courts. And it has direct connection with the delays, judicial delays.
Yes. No, I don't think anyone would disagree, but it is an important question because why is it that governments do not invest enough in having more courts is a question that really needs to be brought to the center stage. But we would be running out of time, so I want to come to Professor Mustafa on the same question of judicial legitimacy. One of the grounds on which the legitimacy of courts is contested is that this is not your job. So what is your view on this idea of the transformative constitutionalism, that should courts take upon themselves the job of transforming society, because that is the promise of a transformative constitution?
Ideally not. I am not a great votary of judges interfering in the governmental jurisdiction. How society will be transformed is basically the responsibility of the society and the government. That's why, judges in policy matters, they say that we are not going to interfere. Selectively they interfere, that's a different story. But judges are not supposed to initiate reforms. Reform should come from within. One of the criticisms of this whole essential religious practices litigation has been that what is essential, what is non-essential in a religion. How can judges who are trained in common law, who are not experts of theology, decide? You can't be privileging one practice over another, because after all it is a package. And there have been, contradictory judgments, There was a reference made to untouchability, for instance. Now, if the question is whether Dalits are to be given position in a temple board or whatever, we need not say that untouchability is not an essential part of Hindu religion. We have to just pass one-line order, untouchability has been abolished, that's it. But I would also like Preetham to react to his lordships on this whole roster business, because what is really happening from a distance, as a keen observer of how cases are listed.
Professor Mustafa, I just wanted to... No. I'm not. I will be with you. Just telling Justice Muralidhar, I'll come to you right after this, because I know you may have a different view. But after you complete.
30
yes.
seconds.
Yes.
Now, judges, they are working with brother judges. They know them. What are their leanings? So the moment Chief Justice allocates case to X bench, the outcome is already decided. Now, that is not good for the judiciary. Now, if for the appointment of judges we can think of collegium, why not for making a roster of Supreme Court? Either we follow what high courts are following, or at least this should be decided by 1 + 2 or 3, at least 2 judges. That. On one more line on judicial appointments, the political class is absolutely unanimous. You see, NJC was passed unanimously in Lok Sabha. And in Rajya Sabha, except for veteran Ram Jethmalani's dissent, everybody voted for it. Yet the court struck it down because they said, primacy of the opinion of Chief Justice is the basic structure. One criticism which is emerging, and we have two very eminent judges on our panel, is this, that judges would be willing to concede ground to the government on everything, except when it comes to their own powers. So be it tribunals, as it recently happened, or NJC, they will put their foot down and they will say nothing, independence of judiciary is basic structure. Now this somehow undermines their legitimacy and people's trust. People don't form a good opinion about judiciary when in their own causes they are far more assertive. Of course, another story is if you have coalition governments, they will be more assertive. If you will have a majority government, whether Mrs. Gandhi or currently, then they will not be that assertive.
So Justice Muralidhar, your hand really shot up. So on these two questions on transformative constitutionalism, and also maybe if you could comment on the question of what do you think are the ingredients for appointment of judges, because we have seen either it's NJSC kind of biased, disproportionate power to somebody, or we have purely judges electing judges. So on these 2 points quickly, if you could respond.
Yeah, on the transformative constitution, I just wanted to add to this debate. See, having been part of the NAS Foundation judgment, I know for a fact of the transformative value of not just that judgment, but that whole arc that followed it. NAS was followed, of course, by Sudesh Kaushal, which reversed it, but NAS was affirmatively, validated by the 9-judge bench in Puttaswamy. 3 of the judgments of that 9-judge bench actually said NAS was correctly decided. And then we had Navtej Johar, which said, of course, NAS was correctly decided and Sudesh Kaushal was not. The whole arc. So I think when the political legal history of the country is written, the transformative nature of NAS followed by Navtej Johar cannot be ignored. We may have debates on how quickly the entire society came about to accept that LGBTQ populations are also, persons entitled to full citizenship, full personhood. But it has been transformative. There is still a large work to be done. Likewise, the NALSA judgment on transgenders has the transformative potential. More recently, the Sukanya Shanta judgment, which called out caste practice within prisons, has that transformative element. So for us to say that courts should have nothing to do with, bringing about or showing any concern about social transformations may not be entirely correct for the same reasons we talked about earlier. These were considered to be numerical minorities. In fact, Sudesh Kaushal very wrongly categorized them as minuscule minorities. Precisely what the Constitution completely put. These so-called numerical minorities could not have had their voices heard but for the space provided by the court. And the transformative element of these judgments is something that we cannot ignore. So this is as far as the transformative part is concerned. But as far as the selection of judges is concerned, I am actually voicing this concern. Earlier I voiced it, I again voice it. We don't seem to have a criteria spelled out on what should a candidate whom we are considering for appointment to a High Court or a Supreme Court should possess. What are the, what are those traits? What are the kinds of things we would like to see in this person? See, that criteria is required to be spelled out. We cannot be silent on it. For instance, let's take the simple thing of designating a senior advocate. All right. Today we are actually spelling out. We are saying, show us at least 5 judgments where your arguments show that you are, have the potential to contribute to the development of law. We say, have you done some pro bono work? We ask whether you, are in your writings, have you, thought about development of the law? Are you be able to have a critical point of view in analyzing the law? So those qualities that we like to see in judges, the capacity to address complex issues, and they're subscribing to constitutional values. This is very, very important. Otherwise, you would not have the phenomenon of a judge, sitting judge of a high court, address a meeting held in the premises of the high court by a certain group which subscribed to a certain ideology, and giving a speech which is now invited, a resolution for his impeachment. It's a different matter that the parliament is not taking up that particular matter for impeachment. But this is something that sends alarm signals that we may have in our midst judges who are now sitting in the benches of the high courts who did not subscribe to the constitutional values. So it is very, very important for us because, judges come from the body of lawyers broadly.
Yes.
And lawyers need not have exposures to all branches of law. So there is some kind of a criteria we need to spell out.
Sure.
And I'm not saying put out the information on all candidates considered. I'm not even going that far. At least the candidates selected.
Yes, some criteria.
Once you select them, tell us what in that evaluation did you consider, let's say, a candidate being selected to the Supreme Court from among the high courts, right? Can you spell out 5 judgments delivered by this person, which tells us that this person is capable of development of the law, capable of deep analysis of the provisions of the law, sticking to some discipline. This is very important. Although Justice Oak mentioned about roster, I think the unwritten problem there is when different judges come to sit on that same roster, they refuse to subscribe to the view expressed by the earlier benches of that very roster. And then the litigant is left hapless. Either the matter then gets referred to a larger bench, or simply this bench distinguishes the judgments of the coordinate benches of that roster. So this is another problem, the indiscipline. But my point is this: not only should we be able to spell out criteria on the qualitative assessment. See, for instance, you have representational needs. You need a representation for the scheduled caste. You need representation for the OBCs. You need representation for the women. But it will get reduced to tokenism if you don't tell us from within that category that the person whom you have selected subscribes or satisfies certain qualitative criteria.
Criteria that should be in place.
To the highest court in the country. So
Justice Mood,
quality.
We get the point, and that's important.
We need to be more transparent about. We need to be more transparent, and we need to reflect in the way we build this data. Will show whether, as a collective body, as the judiciary, we then value these constitutional elements
and whether they live up to them. Yes, I'm sorry to intervene because we are running out of time, and I want a final set of comments from everyone and have maybe some time for audience questions. Yes, we'll come to you. Just one final round of comments, and maybe we start with Professor Mahajan, and everybody, if quickly you could give your final comments. But one question which you may want to address is that, are we lumping everything that we find good into democracy, and are there other things apart from democracy that should figure prominently in our public lives to understand political legitimacy? If you want to take that, yes, but otherwise, final comments from all panelists.
I was just going to make one comment because Justice Muralidhar raised this issue of transformative potential of court's judgment. I think that's absolutely right. It has a transformative potential. But I think this potential is released because the Constitution already lays down certain very significant values, and I think if it were to uphold those values, transformative potential would be realized, rather than merely say that, these are the set of things that we want to see changed in society. That's my view, because I think we may not be able to reach a consensus there, but certainly one can apply, whether it is case of untouchability, it is abolished, or what equality means, how we should treat people of various genders now also as equal. There's a lot of potential there, and I think if that remains the foreground, maybe transformation will happen without necessarily saying, all that. Are we lumping everything into democracy? Perhaps yes, partly because the idea of democracy, I think, has a lot of potential. The lived practice does not. And the alternatives that are there, I think, are still worse off. So perhaps we are lumping there a lot of things there. I think perhaps you are thinking in terms of, are there moral and ethical values which we think democracy should subscribe to? Certainly there are, and we can't abandon that. But I think in terms of, I think this point was raised by you again in the comments, that we have a remarkable constitution. Whether it was by people who were directly elected or not doesn't matter, because there was consensus building that was involved in that particular process. A lot of deliberation, a lot of patience they showed in thinking about these things. I think they have enshrined in it many moral and ethical values which democracies are expected to affirm: social justice, equality, fraternity, various rights that have been given, which are open to subsequent readings so that their scope can be enlarged. So I think we have in that framework several values. If they were to be upheld and affirmed in and through democracy, it would be a great thing, because there are many problems with the functioning of democracy, and I think they come to get highlighted when we focus only on the fact that we have representatives who are supposed to do everything. And I think election is a very small part of what democracy stands for. We need space for dialogue, we need for deliberation, we need for collective reflection, whether it is in the courts or in the civil society or just society generally. So there are many other values which democracy holds the promise for. Maybe we can hold on to them and make some change.
Professor Mustafa?
No, I entirely agree with Professor Mahajan that there is no alternative to democracy, and it has served us well. There have been highs and lows, and as Justice Oak rightly said, that people make governments accountable every 5 years, but the role of the judiciary is to make them accountable during those 5 years. And in terms, I agree with Justice Muralidhar. What I was trying to say, they should not be trying to reform society, but the transformative power of the Constitution through liberal interpretation and implementation of constitutional values is very much the domain of Supreme Court. But I would also say, in terms of representation, a reference was made to women. One, at times it doesn't look good when you say that he is underprivileged judge or he is a Dalit judge, this and that. Probably something is to be done about how the collegium resolutions are drafted. But one has also seen that at times we use this representation to deny elevation to a better judge. So since I don't want a good male judge to go to the Supreme Court, I would pick up a female judge, which really does not help the institution of judicial.
Thank you. Justice Oak?
I will comment only on the issue of collegium. The last point Professor made is the most relevant point, that when we think about giving representation, should we be compromising on quality? That's very, very valid point. Secondly, about collegium, what I personally feel is that I think there should be unanimity on one thing, that there cannot be government interference in the appointment to the constitutional courts. But still, there's scope to improve the existing collegium system till it is replaced by a better system. For example, Justice Muralidhar said, some criteria has to be laid down. Of course, that also is a very difficult job. What should be the criteria? But certain improvements are required. For example, if collegium is dealing with a case, a candidate who is related to collegium member, there should be a provision that after that collegium member recuses, one more senior most judge is added in the collegium. Correct. Even this one improvement which I will suggest, which comes to me offhand. And laying down the criteria, two issues which I want to flag. One, in a lighter vein, I am product of Bombay High Court. We were always told a great story of a great Chief Justice of Bombay High Court. He wanted to elevate a service judge. Then a senior judge went to the Chief Justice and said, "Sir, how can you elevate him? Because there is a prosecution made against that judge under section 279 of IPC for rash and negligent driving." The response of that great Chief Justice was, "He may be a bad driver, but he is a very good judge." Right. Then other issue, which we need to have deliberation. Can you per se, somebody say that a very good advocate, a top class advocate having sound knowledge of law, who has done a lot of pro bono work, can you say that because he has certain political leanings as a citizen, that should apply as disqualification? that issue needs to be deliberated upon. Because one example I'll give you. If that was the criteria, that if you have any political leanings, that's a disqualification, Supreme Court would have been poorer, because Justice Krishna Iyer would not have become judge of the Supreme Court. He was a minister in the government in Kerala. So I don't think we can go to that extreme that, this candidate, he had spoken somewhere and he has indicated his personal political views. That can't be a disqualification. Of course, I want to add a rider in support of what Justice Muralidhar said. But if his utterances, if his writings, his speeches indicate that he has no respect for constitutional values, though he may be a good lawyer, that should be a disqualification. So I think we need to rework on the existing collegium system rather than saying that we completely get rid of that system. I mean, that's the way forward, which I personally feel.
So, last comments by you, Justice Muralidhar, and then we'll open it up for a few questions. We might just, we'll come to it. It's the last set of comments. And yes.
Yeah, so one factor that comes outside of our discussion and which is deeply troubling is this age of social media. And judges are not spared of that social media. And, we have not tried to understand the implications of what is happening in social media, whether in terms of privacy, confidentiality, and our understanding of human relations. There's a whole domain there that requires to be understood, because the control over social media is no longer by the governments. They are by corporate houses located outside the country. So I know I'm saying something completely different from what we've been discussing so far, but this is the power of the foreign corporation or what we think, say, read, understand, and how it's impacting on our current generations, how it will impact on future generations. Because the current generations will be producing the current generation's lawyers, which will be producing the future generation of judges. So I think we have not deliberated enough, and our demand for a data protection law has only recently been answered by those rules, which are completely inadequate. So my last ending comments will be something completely outside the frame of our discussion, but something which should deeply concern each one of us. Thank you.
Thank you. So I know we have run out of time, but in the interest of democracy, perhaps we'll take 3 questions. The first question there, then one here and one here. Yes. Yeah, and I would request the questions to be brief, please. Yes.
Yeah, regarding judges' appointment, why not to have a cadre-based judges like civil service? We have lower court judges also elect by cadre. Second thing about democracy, our elected members are not majority-based. They are 20%, 30%. The way MLA, MPs are elected, they are less than 50%. If we have like a leader of the house 50 plus, we should have MLA and MP also like that.
Yes.
Thank you.
Would you like to take it on judges?
So I have not really understood meaning of cadre-based appointments. Right. Just see now, take a case of our trial judiciary. It's cadre-based because there are regular examination conducted. Then there are interviews, and then by a transparent process, judges are appointed. So do you expect top lawyers in the High Court, to appear for some kind of examination, and so they'll become part of a process and then they get appointed? My personal view is that if we follow that, as it is a dearth of quality, no good lawyer will be willing to undergo this kind of a process. See, ultimately we need quality in the judiciary. So that's very important according to me.
So, okay.
That for this higher judicial services, there were states which just had some kind of interaction. When they introduce written test, the quality has gone down. Many people will not be willing to...
You're right.
So one question there, we can keep it short. First there and then here.
Maybe we can just collect the questions so that we can hear.
Okay, so let's take 3 questions. So brief questions here, and then that question can be answered. Yes. Yes.
I'm sorry I came late, so I might have missed my question, but it's the title of the discussion. In the context of Panchayati Raj, our third tier, despite political legitimacy in theory, it is denied political legitimacy in practice through a whole lot of things which don't attract attention. And I just mentioned one or two examples. The MP LED scheme, giving funds to an MP and likewise to an MLA. What business they have when the panchayats, elected panchayats, have to decide on their planning and programs. So you are undercutting agency. And let alone these, what business? Central schemes, ministries. Then the panchayat is reduced to be an implementing arm. So where is the agency, the political legitimacy of panchayats? So in my view, the courts should take suo motu cognizance of such violations, because that is not the constituency where anybody will file a PIL. They are much too involved in their existential problems. It's enough to manage and whatever.
Sure.
So if we want to give meaning to the third, it's not even a 2.5th tier actually. But if you want to give meaning to a third tier, and that has direct implications on democracy and political legitimacy, courts have a role.
Sure.
I would like your comments. Thank you.
Shall we take one more question and then one there, and we will come back, but yeah, go ahead.
I recall Professor Mustafa stating that judges must act fairly and fearlessly. But what of those judges who do indeed act in a bold manner, that do not fit within the scheme of the executive, and their elevations and their appointments are rather stalled by the executive? Examples coming to mind are Justice K.M. Joseph of the Uttarakhand High Court, whose elevation to the Supreme Court was stalled because apparently
Presidential order.
Yeah, the presidential order. And so would this not beg the question for the continuance of, say, the collegium system, even if it comes at the cost of its perceived legitimacy?
Yes.
No, you're right. In fact,
you can use this.
Yeah. You are right. In fact, what Justice Oak was saying, that somebody's opinion should not disqualify him. We may be in a situation where a thorough research is done on somebody's ideological leanings and opinions, so that we get judges who are tilted towards a particular ideology, which is not good. And you're right. Those 90-page order with Justice K.M. Joseph as Chief Justice of Uttarakhand High Court orally dictated in the court was responsible for his delayed elevation. Certainly. And this should not be there. The appointment of judges to constitutional court should be absolutely on merit.
On Panchayati Raj, if anyone wants to take the question.
No, on Panchayati Raj, what is happening really, that the district magistrate continues to have too much of influence. So that's why it's not taking off properly, but something very positive has come up. About 33% of sarpanches are women. I had done initially training for them. Many of them came with their husbands and father-in-law and were not willing to even talk, but subsequently they asserted themselves. So something very good has happened in Panchayati Raj in terms of 33% seats going to women. But more is to be done, you are right.
On that question, actually, Justice Oak had already in his lecture mentioned that our elected representatives actually do not represent majority, because our electoral system cannot represent proportionally. So that was mentioned and that was agreed to. So maybe two quick questions, maybe one here and one here. So, and we'll stop with that, yes. Maybe you can stand up and ask, the mic can be passed on here.
In terms of political legitimacy, in a lot of these omnibus PILs, I think Justice Oak was dealing with the air pollution. I think we're all suffering due to the air pollution. A common pushback, and I think Justice Gawai has indicated his opinion that he feels like courts should not get into these issues at all. How do you think courts navigate these tricky waters where there's clearly a problem and there is government paralysis? What sort of dialogical structure should the courts be creating? And what should they be keeping in mind in their orders?
So we take
polycentric problems.
Go ahead.
Yeah. Take one more question and then...
You don't want to.
My question was to Sir Mustafa. You mentioned that religion is a private matter and state should not interfere. But in India, religion shapes public life, personal laws, and even access to rights. So if state withdraws completely, wouldn't that allow risking discriminatory practices to continue unchecked? Because how do we actually respect religion freedom with ensuring constitutional equality to all citizens?
Okay. Correct.
I'll answer this question partly.
Okay.
You are referred to my order, I will not deal with that. That's, that's the constraint which we follow. You are talking about environmental matters. Now, Article 21 says that every citizen has right to live in pollution-free atmosphere. Now, where else the citizen will go? Where else he will go for implementation of this right, for exercising his right? And then, when you deal with such matters, if you find that a particular thing is creating pollution, why can't court interfere? Ultimately, when court interferes, court only upholds the fundamental right under Article 21. And please remember one thing, environment, when we talk about environment, sustainable development, etc., when we damage environment, we are doing great injustice to generations to follow. And that's basic jurisprudence we have to remember. That today we are enjoying the world, but we are creating a world by damaging environment beyond repair. So our successive generation won't be able to enjoy.
Yeah, very quickly, the constitutional scheme is like this, that your right to freedom of religion starts with subject to public order, health, morality, and other provisions of this part, which means part 3. So enough powers are already there with the state to bring social reforms and secular activities. What I am trying to say, court should not try to reform religions. Parliament should try to bring reforms. I have been writing that uniform civil code in piecemeal should come. You cannot have any law which is against gender justice. If it is incompatible with equality, substantive equality, then it is negation of our constitutional values. Such laws have to go. Absolutely. What I am trying to say that you can't be undermining the agency. Now saying that women cannot decide their spouses because somebody will have love jihad. You are undermining the agency of adult Hindu girls, which is not right. That is what I was trying to say. But enough powers are there for the state to bring reforms and prohibit discriminatory religious practices, because it is not the personal law, it is the constitution which is supreme. And I would also end, Pratim, by saying that there has been so much of very critical comments about judiciary in our conversation of about 2 hours. Our expectations from the judiciary are very high.
Yes.
But they have been doing a good job, and we are conscious of this fact that there have been some outstanding judgments from the courts. But when you have more hopes from them,
yes,
and they do not live up to our expectations, then you feel frustrated.
Yeah. Justice Muralidhar raised his hand, so maybe if you want to answer one of the questions, and we will stop with that. You also wanted to say, so something quickly then, yes.
There's a practical element to the person's question. We have this device of continuing mandamus. So strategically, a bench which anticipate, keeping in view what is likely to happen by subsequent benches, the way you do a case management, where you ensure implementation even while you are presiding over that bench. I mean, that's very, very important. Sometimes as a court, you have to strategize. Because as far as the legitimacy of intervention, there can be no question. The Environment Protection Law itself has norms, and there are enough judgments on all these things, just as Oak was just mentioning. So on the jurisprudential part, there's no difficulty at all. On the practical part, a judge should anticipate that there is likely to be a different point of view expressed, once the judge demits office. This we've all understood over all these years. So some of us use this device of continuing mandamus to give short adjournments and demand, implementation of our previous orders by the governments while the bench is still seized of the matter. And this is one practical way of going about things. The other, of course, is the Chief Justice being the master of the roster. should ensure continuity by continuing a bench with the other members of that bench. If Justice Oak was sitting with, let's say, some other judge who was part of the bench which gave the judgment, that judge should now be accompanied by other judges so that there is continuity. And like, for instance, there was a social justice bench where Justice Madan Lokur was in the Supreme Court. There is no social justice at all. We can't afford this kind of an inconsistency. Some of these things have to be continued. That's why so much power with the Chief Justice of India is in the expectation that it will be exercised responsibly. And this expectation should not be belied. So this is the comment I wish to make. Thank you.
Okay. So last word, quickly, you wanted to say something?
I don't want to say last word, but there is something I wanted to sort of add on. I think the issue with democracy is not that our governments get elected with 43% and 47%. Even if they have 75%, I think the 25% need to be heard. And I think that's the important element. What kind of space do we have for various kinds of groups to be heard? I think the big task, and that's where my expectations of the judiciary are very high, is that judiciary more than others, and that is where various kinds of arguments really come to play, is how to balance different values, because the Constitution lays down different values. Certainly gender equality is a value, but so is diversity. So we have to find ways in which we balance the two. And if I may say, because you said something which is very important, both of you did, but it could be misunderstood, so I'm going to intervene and say, I think one has to think in terms of also balancing the presence of various groups with the fact that we do not necessarily do injustice to others who are already there. So it's a case of saying, because you may get very meritorious people from various groups. But I think what was intended, and I take you and I wanted to say that explicitly, the issue is how do you balance that no injustice is done to anybody, but at the same time, you have to ensure plurality of voices that come in, because they will bring new perspectives on the subject.
No, thank you very much. I know this discussion could continue for longer. And it was heartening to hear that democracy doesn't reside only in parliament or in court or in the executive, but at different spaces, and we must recognize that. And those who bring balance by listening to others, by appreciating human dignity, as has been pointed out, and looking at our constitutional values and applying them in our daily lives, those institutions have equal democratic legitimacy as others. So this has been coming through from all panelists. So with that, I would like to thank all of you for your time and for your candid responses to all the questions that were asked, and to the audience for being here and asking such important questions. I know we started late and we have tested your patience, but I think we are just 15 minutes off time. To close this, we would like to thank our panelists by showing our appreciation with this small token, just a book, which we would like to give all of you. And I would request our students to come to the stage and hand that over to our panelists. So can I request Pavani Thukural of the third year to please come and felicitate Justice Oak?
That's right.
Yes.
Yeah. Books can be the only.
Yes, it's in books, and I think there's a diary. That's all. Yes. And Sombuddha Paul to come and felicitate Professor Mustafa. And Paul Abraham Chandy to come and felicitate Professor Mahajan. I'm coming to that. Thank you. And Justice Muralidhar, we will drop in at your office to get this book to you. Thank you for being with us. And with that, I thank our panelists and thank everyone else. And our program comes to a close. Thank you.
Thank you. Thank you very much. It was enjoyable. Totally enjoyed it.